Brian Stansbury is a trial lawyer with Akerman in Washington, D.C. 3D printing is revolutionizing manufacturing from prototyping to repair and maintenance. 3D printing is also causing IP and counterfeiting issues, as well as problems of product liability and insurance coverage. Brian will discuss trends and risks associated with this new technology. Please welcome Brian Stansbury.
Good morning. My name is Brian Stansbury. I'm in the Washington, D.C. office of Akerman, and I'm going to talk about 3D printing, what the technology is, how it's evolving, how it's used. I'll also talk about some of the risks associated with the technology and what you can do and what you can advise your clients to do to manage that risk. All right. 3D printing is a form of additive technology where you physically add something to a product to make it rather than subtract it or format it. 3D printing uses computer files to direct a printer to create an object specific to those files. Now, with any new technology, there are numerous applications, and there's often excitement that comes with it. Thus far, there has not been a robust set of litigation based on 3D printed products. Nevertheless, in my counsel I provided to both 3D printing companies as well as more established manufacturers and retail sellers who are incorporating 3D printing technology, I have advised them to exercise caution. It is very possible courts will take an expansive view of liability, given that it is critical that all the risks be assessed on the front end. The risks don't just exist for 3D printing companies. As more companies begin to incorporate this technology, they will begin to internalize some of the risk themselves. All right. So, by way of background, the heart of 3D printing are computer-aided design files, or CAD files. Those of you who have been involved with groundwater contamination litigation may have seen three-dimensional maps that have been developed using CAD files. CAD files are sent to a printer, and it is the CAD files that direct the 3D printer as to how it should be laying the substrate in order to create the object. This is an example of old 2D CAD files compared to the current 3D CAD files that are used to generate 3D objects. 3D printing permits the disaggregation of the manufacturing chain. No longer must all of design and manufacturing occur under the same enterprise. You can have CAD file designers, which are purely software companies, and their designs are sent over the internet or a peer-to-peer network to a manufacturer who uses a third-party printer to thus create an object. This prevents innovation independent of the primary manufacturer or the retail seller. However, it also creates risk. Well, let's start with the uses of 3D technology. We can talk about the risks afterwards. 3D technology is being used quite often for repairs. Currently, there are refrigerators being developed that will print out replacement parts and install them without you ever knowing about it. 3D printers can also be used to cut down on your inventory costs. Rather than keeping numerous products to address your customers' desires, you can customly print products on site and thus cut back on the cost of inventory, which any in-house counsel knows, inventory equals money going the other way. Moreover, 3D printing can cut down your transportation costs. You no longer have to send products across the country, you can just print them. This can be particularly useful when you have to do a repair in short order. For example, if you're operating an oil rig in Nigeria and a key part breaks down, currently you would have to ship the part from China or the US to Nigeria, which takes time, and then good luck dealing with Nigerian customs. That's never fun. All along, while you're offline, it's costing you money. With 3D printing, the replacement part can be printed on site, reinstalled that day, and the rig can go back online. But I think the most exciting applications of 3D printing involve its use in the medical space. We see 3D printed casts. Now, anybody who has broken their arm is still using the same basic technology that's existed for a century of these plaster casts. And anybody who has worn a cast and had an itch halfway underneath knows how horrible that is. But now we can generate specific 3D printed casts that are designed to address the individual characteristics of the bone and are made with minimal amount of material, thus allowing you to scratch that itch through the lattice. In August, FDA approved the first ever 3D printed drug, which is an epilepsy drug, and there is even an emergence of 3D printed food. We also see 3D printing in space. If you remember that scene from Apollo 13, where they have to fit the air filter, the square peg in the round hole, and they dump the box of stuff on the table and figure out what we can use to make this, because this is the objects we have up in space at this time. Recently, there was a repair on the space station. They didn't have the tool to do it, so rather than ship up the tool, NASA emailed a file to the space station, and using the space station printer, they printed out the wrench they needed to make the repair in a matter of minutes. Finally, one of the other big high-profile developments was the 3D printing of jet engines by an Australian company. This shows the example of just how complex 3D printing can be, but I think this is a great example to highlight the risks that exist, because while it is exciting to think of being able to produce engines in a more efficient manner and perhaps allowing countries that don't have the current capacity to create engines using 3D printing, what happens the first time a plane falls out of the sky with a 3D printed engine? Best believe the 3D printed engine will be the target of every other product manufacturer on that plane and blamed for the failure. So let's talk about the risks and how they'll be addressed. First, the issue is whether there'll be strict liability or negligence. For a retail seller, they're going to face strict liability, regardless of whether they created the product using 3D printed technology or not. However, there are other players within the chain, including the CAD file designer, the streamers of the data, as well as the manufacturers of the printer. Questions remain as to how they will be treated should they be sued as well, or if a contribution claim is brought against them by the retail seller. Let's start with printers. With respect to a printer that is not defective when it leaves the factory, that printer will not be subject to strict liability, provided it is not defective when it leaves the factory. However, a 3D printer that is not defective can still print a defective product if there's a problem with the CAD file or if there's a problem where the data is corrupted during the stream. Now, strict liability is usually imposed on manufacturers and retail sellers because they are in the best position because of their knowledge to ensure that the product is safe. But with 3D printers, by design, they are going to make products that the manufacturer of the printer could not have foreseen. Thus, the reasoning for strict liability isn't as applicable to a working 3D printer that will not know exactly what products are being manufactured. This defense is less viable in an industrial setting where there is a 3D printer that's being created for a very specific type of practice where the product is more foreseeable. With respect to CAD file designers, the primary issue there is whether CAD files will be considered products for purposes of strict liability. Courts have treated intangible objects differently in this question. For example, electricity and navigational and aeronautical charts are treated as products. However, information in books and contents of video games have not been treated as products. Currently, there is not a case out there determining whether a CAD file used for 3D printing will be used or treated as a product for purposes of strict liability. Data streamers are likely not to face strict liability either. Again, there is not direct precedent on this point, but one can look at other areas where internet service providers have not been subjected to liability, such as the Communications Decency Act, which said that a internet service provider which is used to transmit indecent material is not considered a publisher of that material. Moreover, it is not possible for an internet service provider to foresee all the various products that could be streamed over its network, and thus is not in a position or does not have a duty to any end user. Now let's talk about CAD file designers facing negligence, because even if they're not considered a product, there may be instances in which there is a good case to be made that they do in fact have a duty to an end user. In this instance, the questions will turn on the type of injury, whether it's economic loss or personal injury, as well as whether the CAD file designed, what purpose the CAD file was designed for. For example, earlier when looking at the cast, that is an example where the CAD file designer designed the cast specifically to address the needs of one end user and understood completely what the risks of product failure are, exacerbating the injury. Same would apply to the manufacturer of a jet engine. It is very foreseeable how that product will be used, as well as the injury that would arise from that. Thus, CAD File Designers should be aware that, particularly in these areas, medical devices or highly specialized equipment, they will face potential liability should it be shown that the CAD file was defective in some way and produced a defective product. As for printer manufacturers and data streamers, once again, for the similar reasons that they're not going to be subject to strict liability, they also have strong defenses to a negligence claim. For example, a printer manufacturer will not know the specific qualities of a product being printed, and the data streamers will have a strong basis for asserting that they are not aware and cannot be aware of who the end users of a product streamed over their networks are. Now, I also want to raise the issue of IP issues because while this is something that could be talked about for an hour in its own right, 3D printing does create a variety of intellectual property concerns which can confound not only traditional 3D printing companies, but also companies that incorporate the technology. Just because you can print a product that is patented doesn't make it legal. And sometimes when dealing with 3D printing companies where innovation is the key, they can view patent law as a hindrance to that progress. Moreover, there should be concern about vicarious infringement that if you were to use CAD files that were created in a way that infringed on another copyright or patent holder's rights. Moreover, there's also great opportunity for rampant piracy and counterfeiting of trademarks when people can print objects at home and add a trademark on their own in a way that would make it indistinguishable from yours. Once again, these are also risks that should be aware with respect to entering into 3D printing, as well as being aware that this technology poses to any company, regardless of whether that company is adopting 3D printing itself. So let's talk about addressing some of the liability issues. First and foremost, due diligence and quality control. All market participants should assume that there will be a broad application of liability and plan accordingly. First, establish quality control mechanisms that are specific to 3D printing and are cognizant of the specific points of failure that exist. CAD file contamination through streaming, defective CAD files, defective printers. Ensure that all the players, particularly in this disaggregated chain, to the extent possible, are aware of each other and are aware of how their technology is intersecting. CAD file designers who are unaware of how a particular printer will respond to its files may shrug their shoulders afterwards and say, well, we didn't know. But as an in-house attorney, that's not the answer you want to hear when you're being sued. Ensure on the front end that the CAD file designers understand the printers you're using and are clear that those printers can understand the code. Data security is another big issue to be aware of and another area where robust management can prevent risk. Now, we're aware of the data security issues that any in-house counsel faces all the time. But with respect to 3D printing, it is very possible for sabotage to affect how the CAD files are read by the printer and could lead to minute changes that render a medical device dangerous or unworkable. Even if it is shown later on that the retail seller's product was defective because of data security violation, that company may still be subject to liability, especially if it did not have a robust protective system. One way to avoid this is to encourage use of private peer-to-peer networks for streaming of CAD files as opposed to publicly available internet sources. Traceability is another issue to consider, particularly if you are manufacturing products that are indistinguishable from each other, such as screws. You can still, in the CAD file level or on the printer level, imprint a microscopic mark that will allow you to distinguish your product from another product should there be a lawsuit involving product failure. In advising my clients, I always push seeking indemnification rights, particularly when dealing with CAD file designers who are making very specific products and selling them for a high cost. However, because some players within the 3D printing universe are startups and do not have the cash flow that some more established companies do, they're somewhat judgment-proof. And so the indemnification right can be limited, which is why insurance has to be a key component of any in-house counsel's or outside counsel's approach to identifying and managing risk of 3D printing. Here, the landscape changes dramatically. For CAD file designers, they may have to take out a class of insurance they previously haven't. Many of these software development companies aren't thinking about product liability when designing their products and don't have a history of that type of insurance. The insureds must also be aware of the specific risks that exist when the insurance companies must be aware of the specific risks that exist for insureds that adopt 3D printing technology. For example, 3D printers can emit toxic fumes which can cause workers' comp claims and create environmental emissions. Moreover, the scalability of 3D printing, which makes it so appealing, also creates problems for risk management. A CAD file designer may have no idea just how widely disseminated his or her product will be. It can be used all around the world and at a much greater scale than initially envisioned. While this is great for profits, it can also create risks that are not foreseeable. Insurance companies must make sure they understand what potential risks exist, including in markets that aren't necessarily markets that they would normally assume that product would be found. As for IP protection and compliance, once again, it is important to have specific protocols that not only are focused on protecting your own intellectual property, but are ensuring you're not infringing on others. In some cases, this requires talking with various portions of the company that don't have a history of focusing on intellectual property. For example, if you have an employee whose job it is to acquire or use screws or other parts that are being made by 3D printing, that individual may not have a background in trying to ascertain whether the CAD files used to make that product were infringing upon another CAD holder's rights. So it's important that you identify every place where these products are being used and are ensuring that you are not vicariously infringing by using 3D printed technology. In conclusion, I appreciate your time and attention, and I hope that you are able to use this presentation to have a better understanding of how 3D printing works, what its applications are, and able to identify, manage, and reduce the risk of product failure, infringement, and ultimately litigation. Thank you.